Morning, everyone. It's nice to see you all here. My name's Tate, Chakrabarti. John's very kindly introduced me. I'm Senior Privacy Counsel with Reckitt, Benckiser. This is the first time that I'm presenting at one of these events, so thank you for inviting me. I hope that I can add value to the proceedings. By way of introduction, my role as Privacy Counsel with RB, it involves a whole gamut of things associated with data privacy in connection with RB's global operations. A bit about RB, we are a FTSE 10 company, and some of our well-known brands are listed here. I'll just let you all have a quick look before we move on. There's a lot to get through today. Okay. I picked 7 topics, of which I believe things associated with privacy will come to the fore in 2020. There's a lot to get through, as I've said, so let's move on. The first of these is to do with privacy regs globally. It sounds cliched, but in 2018, when the GDPR first came into force, it really was the beginning of a new era in connection with data privacy. The new law, in effect, it showed the way and the world what a modern framework for privacy law should be. In 2020, more countries are aiming to adopt privacy laws. A lot of these are inspired directly or indirectly by the GDPR. All of them, however, are concerned with the processing, storage, transfer, usage, and protection of personal data. And for those of you who aren't aware, personal data is data by which you can clearly identify an individual. That's what the fuss is all about. That's what privacy at its core is all about. So I picked 3 jurisdictions to talk about briefly, California, India, and Brazil. We start with California. The California Consumer Privacy Act came into force on the 1st of January this year, just a few weeks ago. It is in part inspired by the GDPR, and a handful of other states in America, some of them have implemented smaller DP laws. I think it's Maine and Nevada, and in the year ahead, I think the state of New York, the state of Washington, Massachusetts, and Texas, they will be implementing large bills themselves. Why is California significant? A lot of you here today work in the cyber industry, in tech industries. California is the home of Silicon Valley. A lot of the agreements that you will put in place may have California given as the jurisdiction. Be aware of the new laws which are now in force. Moving on to India. India is also about to unleash its own data protection bill later this year. Its goal is quite straightforward. It's to protect the personal data of its citizens and to put a framework in place for that. Again, quite similar to California. A lot of you here today are involved in technology and cyber. Most tech companies have subsidiaries in India or they outsource there. So if you are going to be handling data associated with Indian citizens, be wary of the new laws. And finally, Brazil. Brazil is the largest internet market in Latin America. I think there's about 140 million internet users there. Currently, there's about 40 smaller privacy laws which operate in the country, but on the 15th of August this year, there's going to be a new law coming into force. It's abbreviated to the LGPD. My Portuguese isn't as good as it used to be, so please don't ask me to say its name in full. Again, if you are going to be handling personal data of people in Brazil, be wary of the new law. Moving on to the second topic, data retention. Data retention is something that's enshrined within the GDPR and virtually all privacy laws which are coming into force in the year ahead. You'll probably be asking the question, why has he picked this topic? I'm going to answer that with another question. What will the cost of non-compliance be to your company on this topic? On the 30th of October 2019, just a few months ago, the Berlin Data Commissioner, they imposed a 14.5 million euro fine upon a German company called Deutsche Wohnen SE. They are a real estate company, and what was found that they had a data archiving system which didn't allow for erasure of personal data. Once the data commissioner took a closer look at what was held in there, they found things like tax data, employment contracts, lots of other things which contain personal data of individuals. They immediately took the view that archiving without the possibility of erasure, this was a clear breach of Article 25(1) of the GDPR and also the general processing principle of Article 5. As I say, they were very forthcoming with the fine. They were highly critical of the company, and 14.5 million euros was 2% of the company's annual turnover. Again, I'm choosing to mention this because, in my experience, a lot of companies globally now, they are quite far ahead with their privacy programs. But data retention is often a small topic that's overlooked. If your company's not compliant with this within your own privacy programs, please ensure you are. If not, you could find yourself to be the target of a regulator. The next topic is going to be fines in general. If I start by saying that there's two tiers of administrative fines under the GDPR. The first tier, the lower tier, the fines tend to be sandwiched in between 10 million euros and 2% of the company's global turnover. The example I used previously, Deutsche Wohnen SE, they were fined 2% of their company's turnover because issues to do with data retention were deemed to be a lesser fine. For upper level fines, and this is more serious offences, the fines are sandwiched in between 20 million euros and 4% of the company's global turnover. To give you an example using my company, Reckitt Benckiser, our global turnover is something like £13.6 billion annually. If we were fined 4% of that, it would be something in the region of £670 million. That's what all of you are facing out there, so please be aware of this. When the GDPR first came into force, there was almost unofficially a grace period that all regulators all over the continent granted companies. They gave them a year to 18 months to become compliant with the new statute, understand how it works, and put policies in place. That grace period has now passed, and I'm firmly of the opinion that in the year ahead and beyond, more and more regulators will flex their muscles. The current record fine stands at 55.4 million euros, and that was issued by CNIL, who are the French regulator, last summer. It was issued to Google. Perhaps no surprises there. With regards to what this means for your company, if you are levied with a fine, consider the damage to your company's reputation. This can often take years to restore or repair. You also open yourself up to third-party claims. In simple terms, under DP laws, individuals who suffer losses as a result of your company's breach can sue you for it. And finally, if you are a listed company, there's the issue of the share price falling, and that's not something anybody wants. Brexit. I don't think any conversation or presentation anywhere in the land this week is going to be complete without mention of the B word. I could probably talk about this for an hour, but I'm going to give all of you the highlights in essence. Now, as we all know, Brexit is about to happen. Later this week, on the 31st of January, we are leaving the EU. At that point, the government has until the 31st of December 2020 to negotiate and sort out our future relationship with the EU. In terms of privacy, the law that's going to be in place during the transition period is the Data Protection Act of 2018 and also the GDPR. It's been agreed that during the transition period that's going to stay in play. The government has issued a statutory instrument. In simple terms, that's a way of amending the law. So the Data Protection Act is about to be amended further, and more aspects of the GDPR are going to be inserted into it. The reason for this is something called adequacy. When we leave the EU in a few days, we will be deemed in the eyes of the European Commission to be what's called a third country. In simple terms, we will now have to prove to them that our data privacy laws are equivalent to, compliant with, and as good as what operates within EU member states, i.e. the GDPR. I'm not optimistic that this will be achieved in the timescale that's required. The last country to be granted adequacy was Japan. This was last year, and the whole process took 2 years to achieve. We have 11 months. Let's see how things go. Cyber insurance. In simple terms, if your company doesn't have a cyber policy, take one out as soon as you can. It's perhaps one of the most commercially sensible things to implement in the modern world. I'll just say a couple of things on cyber and policies as they stand at the moment. It's still quite a new market. People only really took an interest in it after the GDPR came into force. And what we find is that amongst policies which are provided by different insurance companies, there's a lot of variation. Perhaps part of that is that there's been no clear guidance yet from a regulator, either from a data privacy regulator or from an insurance regulator, over what should be industry standards. So if you do have a policy, or if you are going to take one out, read the fine print and understand exactly what's needed to trigger your policy. This is a topic that I often talk about with other legal counsel and our counterparts in private practice. If you are going to be taking out a policy, try and ensure that you are covered against ransomware attacks and extortion threats. Make sure that the scope of the coverage is very broad. If you keep it narrow, in simple terms, you're making a rod for your own backs. If you can, keep property within the scope of the cover. And the reason for that is even now, property is often the largest asset that a company owns. And this is a personal favourite of mine. Always avoid handing over control of litigation to an insurer or a third party. The reason for that is very simple. I believe that every company should be in control of its own destiny at all times. There's three topics which I cannot really go into in much depth, but I just want to mention them briefly. In the next year, ad tech, biometrics and 5G, privacy issues associated with these will be massive. All over the media, keep your eyes out. I can talk about them more in the panels if people have questions there. But the final point that I want to close on, it's not really to do with personal data, but this is an issue called data localization. Most companies are not really aware of what this is, and in simple terms, certain jurisdictions are keen to restrict any data, not just personal data, but any data associated with their citizens within their own jurisdictions. In simple terms, if your company does business with either China, Russia, or Vietnam, please be mindful of data localization practices. And I'm just going to finish by saying that the penalties for not complying with these are not just fines, but they are criminal sanctions. And senior directors of your companies that are based in those jurisdictions can be jailed. Please be mindful of it. If you're not sure, seek legal advice on it. That's the end of the presentation. Thank you very much.